on. Brendan.
I think it is.
Okay, good evening, ladies and gentlemen. We're going to make a start. Hello? Hello? Yes, okay. Hello, we're going to make a start. If people like take their seats. Don't get done.
The acoustics are not good here.
Yeah. Clearly couldn't do it out. Clearly do it out the mic.
I think it is working.
Yeah. Okay, you're all very welcome this evening. We're going to start now shortly. Just very briefly, just to welcome everybody here. This event has been organised by the Lawyers Christian Fellowship and the Afro-Irish organisation, and thank you all for coming, and particular thanks to all our speakers and to Mel Christle, who's going to chair it. The Lawyers Christian Fellowship have organised a number of events and talks throughout the year, and we'll finish with our summer barbecue on the 12th of July, so if you keep an eye on our website, you'll be notified about that. So without further ado, I'm going to hand over to Mel Christle. Thank you very much.
Without any further ado, so that we can compartmentalise this discussion or talk in as short a time period as is possible, hopefully an hour and a quarter, in circumstances where each of the speakers will address their topics for, we say, a maximum of 15 minutes, and in that way we'll be on our way. The general topic is ethics in immigration law, and each of our speakers will speak to a specific area of that general topic. And our first speaker is well known to most of us here, and that's Sunniva McDonagh, Senior Counsel. And Sunniva, as you are aware, practices in the area of administrative and judicial review in the main, as well as other areas. Would that be correct? And she is going to speak to you on the subject of ethical aspects of immigration and asylum judicial review. So without further ado, Ms. Sunniva McDonagh.
Good evening, everybody, and thank you very much for the invitation to come along here this evening. I hope that you can all hear me. The answer, I hope you can all hear me, yes? Well, I'm just going to make a number of points, because I think the essential thing about any code of ethics is that a code of ethics is organic and grows from the bottom up, and is not something that's imposed from the top down. And so therefore we would very much welcome any contributions that you have to make. I'm going to throw out a few ideas that I have. You yourselves may have other ideas, and I hope there will be a time at the end for discussing it. And I apologise in advance if my talk is very specialised in relation to barristers practising in the area of immigration review. I hope it's not too narrow. But I suppose I haven't had the benefit of a classical education, but I understand that profession comes from the Latin professio, which is I stand before you. These things I hold you to, very much as our sponsors this evening are a Christian group, but very much the way you profess something in religion. So the professions, whether it be medical, legal or whatever, hold certain values that they will stand for. And that's, I suppose, the basis of ethics. And the bar has its own code of ethics in the Bar Council Code of Conduct. It's not a complete, it's an organic document that will change from time to time, but it does address some of the issues that might arise. But I was just thinking, when I was looking at the Bar Council Code of Conduct as an organic document, when I started at the bar, one of the items in the Code of Conduct, mind you, was that lady barristers shall not wear culottes. Now, I don't know if you know what culottes are because they're probably gone out of fashion so long ago, but the whole idea behind culottes is they look like trousers, so you don't know whether a lady barrister is wearing culottes or not. Now, happily the bar has moved on, but it just shows you that originally it was a collection of rulings made by barristers in circumstances which arose in various cases or issues which came before the Bar Council. So I'm not going to, in this talk this evening, give you a list of issues which have arisen in my own practice, which I might regard as ethical issues, in the sense that many of you also may be aware of the Father Ted series, where Father Ted in the series is awarded the Golden Cleric Award, and he gets up to make a speech, and it's just a series of gripes that he has against people over the years, and he goes on for hours and hours and everybody leaves. So that's not the purpose. The purpose is to engage you so that we can, in fact, together see what might be an appropriate way of looking at barristers' ethics. And I suppose the first question that occurred to me is what is at stake here, because the bar is in a state of possible flux, and there are many changes ahead, and some of them may be good and some of them may not be good. But one of the things that the bar has always felt to be very important is the sole trader rule. The idea that you are one person representing your client, you're not somebody among others. The bar has defended this rule because it sees in it some greater good in relation to the protection of clients' interests. But it has also been criticised from outside the bar as not necessarily being the most suitable model to enforce ethical conduct. So I just thought I'd read briefly from what Paul Gallagher, our former Attorney General, wrote about the matter in the Bar Council review, and then just refer briefly to some criticisms of it, so that you can reflect as to whether or not, especially in immigration law, the sole trader rule, if there are special considerations we need to give to ensuring that our independence is preserved. But in an article in the Bar Review that Paul Gallagher wrote in 2005 under the heading "Can Ethics Be Competitive?" he said, "There are a number of core rules which define the independent referral bar, which is comprised of practising barristers. These rules are enshrined in the Code of Conduct. Barristers are individually and personally responsible for their own conduct and for their professional work, and must exercise their own personal judgment in all their professional activities. They must be absolutely independent and free from all other influences, especially such as arises from their personal interest or external pressure. A practising barrister has an overriding duty to the court to act with independence and to ensure in the public interest the proper and efficient administration of justice is achieved, and that the court is not deceived or knowingly or recklessly misled. A barrister must conduct proceedings economically and bring all relevant authorities to the attention of the court, whether or not they assist the party for whom he/she appears. He or she must bring to the attention of the court any procedural irregularity which occurs during the course of the trial, ensure that the court is not invited to enforce an illegal transaction, and not make allegations of dishonesty without a proper basis to support them." And he felt that this is best achieved by the sole trader rule, because he said that barristers whose daily task it is to practice before the courts in a wide range of cases acquire not only a greater expertise in advocacy, but also help to create that atmosphere of judicial trust which is essential to the proper working of the system. Judges know that the individual barrister is aware that it is his/her reputation which is on the line, and that it is he or she who must maintain the trust of the court. The individual barrister bears the individual responsibility for the presentation of the case to the court. It is that shouldering of the individual responsibility, that individual answerability, which helps ensure the ethical duties to the court are discharged. Further, it is that individual responsibility and freedom that enables a barrister to fearlessly protect his or her lay client's interest without having regard to what other partners in a law firm, for example, may think or want. There is no pressure on the individual barrister to account to other partners for his or her time or income generation, or for upsetting a particular client through ethical disclosures to the court. The independent bar is perhaps the core principle because it greatly facilitates the operation of the cab rank rule. It reduces the external pressures which might otherwise make the discharging of the overriding duty to the court more difficult, and it imposes the personal responsibility and the personal exposure to judges which is conducive to compliance with ethical principles. The independent bar is vital to the success of that system, even if it's not the only vital component. Now, the bar has been criticised by other organisations, not least the Competition Authority, who make the following points about the sole trader rule and barristers' obligation to the courts. They say it's not correct to describe the sole trader business model as one free from personal interest or external pressure. Any sole trader will tell you that he or she has a direct personal interest in the business. Indeed, for some sole traders, a single large matter may make or break them, particularly in the early stages of their career. A sole trader may also be more economically dependent on one client from either the private or public sectors, or on one matter, than would be the case for other business structures. The key issue is the relative incentives on barristers in different organisational settings, and unfortunately the lacuna in the reasoning of the Bar Council argument is not to recognise the strength of the incentives for sole traders to take unethical shortcuts. The sole trader is more exposed to the risk of the business venture than in any other business structure. And they conclude, another strand to the pro-sole trader argument is that the individual barrister bears the entire cost of any sanction for a breach of the ethical rules. And as Paul Gallagher said, it is the shouldering of the individual responsibility, that individual answerability, which helps ensure the ethical duties to the court are discharged. That the risk of the sanction is not shared or not diluted by others is, the competition argue, as much a weakness as it is a strength. To take the example of barrister partnerships, the entire partnership will suffer in the event of an ethical lapse. As the reputation of the firm is on the line, the partners have an interest in maintaining a high-quality legal product. A partnership will thus have its own ethical rules, as the partners know that they are liable for the mistakes of any one of them, etc. So I'm just pointing out that there are views out there, and there may be issues coming down the tracks for barristers, and I think especially immigration law presents its own unique challenges, and that's why I'm going to look at that model. Because in immigration law, as it's practiced in the Irish courts, as you probably know, mostly the barristers who practice act for one side or the other, and not generally act for both sides, whereas in any other branch of law that I am familiar with, you generally have barristers prosecuting or defending, or you have employment lawyers acting for employers or for employees, etc. So that in itself presents its unique set of challenges, and we need to think, if we're going to maintain the sole trader rule, how these high ethical standards of duties to the court, etc., can be discharged. In immigration law, I would prefer if we're looked at in the wider context of judicial review generally. There was no such thing, believe it or not, as immigration law as a specialty in Ireland 10 years ago. But there have always been cases of people coming to live in Ireland or seeking to remain in Ireland. I mean, obviously, it's the history of our country. So there have been cases dealing with foreign nationals for decades. But it's only in the last 10 years that immigration law has come to be seen as some form of special practice of the law. And I think there's a danger when we're talking about judicial review to say that this is divorced from other areas of judicial review, because, of course, if a matter goes before the Supreme Court, all appeals in all areas of judicial review and constitutional law and administrative law go to the one Supreme Court. And I think it's an important principle in immigration law that we're very mindful of developments in other branches of the law, and that it is not seen as somehow having its own special applicable rules, but these areas of law can learn from one another. And I think that's an important point to make. Now, I hope that if I'm focusing on judicial review, I'm not focusing on some of the negative aspects of cases that come before the courts, because I will be dealing briefly with issues of credibility, which of course don't affect the vast number of cases coming before the courts, but it is an essential issue, especially in asylum law, and that would be the international experience. It's not just an Irish experience. So in relation to the practicing of judicial review and the code of conduct, I mean, one of the first duties of a barrister under the Code of Conduct Rule 5.4 is to put the law before the court.